points that he has been present. Firstly, the vehicle was not insured.
Yes.
And the second point, regarding some deduction. That the LCR matter subject to matters. If LCR is not the matter, because during the course of the trial, a petition has been filed by the present attorney in India to delete the name on the ground that the particular branch was not regarding which one photocopy of the policy was filed by the claimant.
The LCR is here. Call for the LCR. Yes. You use the microphone. It's glass partition.
Stay is operating in this case alone. Then we have filed ID for the getting of the stay alone.
No, the question is, if the vehicle is not at all insured.
Vehicle is insured, that is only the
wait for 2 weeks. Call for the lower court records.
Serial number 29, MA number 503 of 50, Mr. Alok Lal for the appellant, Mr. Amit Kumar Kamble, Mr. Kumar for the respondent.
In this case, the deceased was traveling on the auto rickshaw. Now, kindly come to the evidence of the claimants themselves.
In this case, I have received Wakalatama on behalf of respondent number 2 and 3, minor sons and daughter of the respondent number 1.
Who is appearing for the respondent number 1?
I am.
So they are minor. How can you get a wakalatama? You have to. It has to be signed by the mother.
Yes.
You file wakalatama. Yes. What is your ground?
Well, the ground in this case is that this was an auto rickshaw insured with us. The deceased, he was traveling on the auto rickshaw along with 10 to 12 passengers, which is having a seating capacity of only 3 persons. It overturned, causing death of the deceased. Against that, a claim has been raised. Now, in this case, our specific contention before the lordship is that we are admitting the insurance, but the owner
It's overloading.
Overloading is overloading. And in case of overloading, as your lordship is aware, it should be right to have the law also. That Supreme Court, Honorable Supreme Court has said that pay and recover part will apply. That is the first part, that is the first level.
LCR is here. Counsel for the appellant submits that though the vehicle was insured by the appellants, yet from the evidence it would be quite clear that the vehicle was overloaded with passengers. He submits that the offending vehicle is a tempo, capacity, the sitting capacity of which is 3 in number, whereas from the evidence it would be quite clear that 12 passengers were traveling in the same tempo. So next part. Considering his submission, call for the local records.
Serial number 30, MA number 524 of 50, Mr. Alok Lal for the appellant.
This case was yesterday also, I don't know whether it will be taken today or not, but it will happen. In this case,
Yes.
this was listed yesterday also. But since the court was not.
Was this yesterday? Huh?
I will check.
But in possible to lordship direction, we have deposited the amount, we have paid the amount, and deducted the amount to the account of the claimant. Now, in this case,
You have paid, you have received the
Lord,
amount.
just 9.47 lakh has been.
So there is no issue so far as you are concerned.
no problem.
So now, you are the owner.
He is the driver of the other truck which was not insured.
Okay.
So my claim is against the truck which was insured with us. Now, what the tribunal has committed an error, kindly come to page 7 of the award. The last paragraph, keeping in view, page 7, what about it? Keeping in view the cited decision, I find that substance in the argument of the counsel for a claimant can receive the entire amount from an oriental insurance company. So far, the things and terms and conditions of the insurance policy is concerned, I find that oriental insurance company about to give A, B, and C. That goes to show that the license of driving license for LLP was issued in the name of Rameshwar Devani and not in the name of Bablu. It is important to mention here that the owner driver did not appear despite the service of notice and further proceeding to go ex parte against them.
So what is the status in this case, owner and driver?
Still already feel that there is no, I am not aware of the procedure of the notice. Here in this case, the observation of right to belong has to be given. But surprisingly enough, that has not been incorporated in operating part of the order. That is nothing else.
But he has to, notice has to,
Notice is not
Be
issued.
sent.
Notice was issued.
has not been received.
I am not aware of the status of the notice.
That is, owner is respond number. You are 7.
Why?
5 not sufficient.
5 is well, we are the children of WB 374085.
No.
That is respond number 6. I am concerned with 6.
What about, go through the office note and see. There is no order which says that case will proceed ex parte.
No, here it is not any. In the lower court it was that. I have already
No,
seen
but
that.
at least
That was
no one
not
appears.
on the tribunal.
I don't think so. Notice have been validly served also. You go through it. Go through this.
Serial number 31, MA number 79 of 60, Mr. Alokla for the appellant.
Yes, Mr.
Well, there is nothing much in this case. We have taken account that Khalasi was not covered. Khalasi was repairing the truck, and in that case, the driver has drove the vehicle. And as a result of this, he was crushed. I will come to paragraph 27.
Paragraph?
27 of the code.
Yes.
This can be done with.
Why right to recovery from the owner?
Because no premium was paid for the Khalasi. The seat was stated to be Khalasi working under the truck, and he was run over by the truck.
So, what do you say?
Unless and until the premium is being paid, the Khalasi are not covered. Unless and until the premium is being paid, the Khalasi are not covered under the following under the Act.
No. You have got the right to recover the amount.
Yes, but that's what I'm saying. That can be done.
Here. Or the counsel for the applicant, Mr. Alok Lal. Yes, sir. The insurance company has challenged the award dated 5th February 2015, passed in title motor vehicle number 182 of 2004, whereby a sum of rupees 5,19,200 has been awarded in favor of the claimants by the Motor Accidents Claim Tribunal of District Judge 5, Dhanbad. First up, Mr. Alok Lal, appearing on behalf of the applicant, submit that admittedly the deceased was a cleaner within bracket Khalasi, working with the vehicle JH10B, B for Bombay, 7975. He submits that on 31/8/2014, when the said Khalasi was checking the vehicle, the driver, the driver started and plied the vehicle, as a result of which the deceased was smashed by the back wheels of the tipper. Next paragraph. And the next line. It is his contention that since the Khalasi was not covered by the insurance policy, the insurance company is not liable to pay any amounts. Next paragraph. Full stop. This is the only point which has been raised by the insurance company. Next paragraph. After going through the impugned award, I find that in paragraph 23, the tribunal has held that has given
27.
paragraph 27 has held that there was no insurance coverage of the cleaner. After holding the same, the court directed the tribunal directed the insurance company to pay the amount and recover the same from the owner of the offending vehicle. Next paragraph. Since the right to recovery has been given to the appellant insurer, and considering the fact that the legislation is beneficial, I am directing the insurance company to pay and recover the amounts as directed by the tribunal. Thus, I am not inclined to interfere with the award.
Statutory
Award. Application is dismissed. Full stop. The statutory amount should be refunded to the insurance company.
I would say that at least P26 is not listed every amount in place. I have to keep reprisal very long these cases. कल भी जो है यार दोनों 26 केस करवा दिए.
Serial number 32, MA number 95 or 60, Mr. Idris Sinha, Mr. Suraj Singh for the appellant.
Limitation. The limitation has not been controlled.
There's a period of 90 days.
90 days.
I have subsequently done my development with the
So there is a delay of 90 days. What do you want to say on the delay? Employees Compensation Act. What is the provision? Section?
So 30
Yes.
section
7
30.
or 30. 30.
Yes, sir. Appeals and appeals are like to be high
Yes.
court from the following laws.
Yes.
31A is an order in lump sum. I was volume 31AA, an order awarding interest and penalty in the section. The difference between A and AA is that when lump sum compensation is awarded in 31A, they will spend with compensation along with interest penalty in 1 year.
No, first delay has to be, see,
Yes, sir. I am saying that it has to be 30 days.
60 days.
60 days, sir. It has
60
to be
days.
60 days. There is
And now your case is 30 days beyond that 60 days.
90 days.
90 days beyond 60 days. It's a 30 days delay, 90 days delay.
90 days.
Yes.
Very small amount of just 2 lakhs.
Even 2 lakhs, let's see what is the.
But the entire individual amount was deposited. We are only asking because in this.
Have you withdrawn the amount?
They,
What is your submission on this delay?
because the delay application, I'll file a reply to this, because I'm filing after the previous council, the traffic manager was there. Like that. I'm filing a reply in the I was unaware whether it has been controlled or not, since it has been admission. Since the matter is listed under admission, I was unaware whether the delay has been controlled or not. I'll file a reply on this. But I cannot do, because for receiving an appeal and the WPA, the statute provision is that they have to deposit the entire amount before the court. That is why they have deposited.
Mr. Vimos Sinha, come to paragraph 7. What sort of false statement you have?
Once the applicant company has decided to prefer an appeal in terms of section 30, the funds were required to be arranged, which are
Steel Authority of India, as I know, they don't arrange funds for preferring this appeal at the time of filing this appeal.
approval for filing.
No.
We have filed.
No, it's not approval.
But
You say that you needed fund, for which approval was sought for? Don't try to deviate. Don't try to deviate now. Steel Authority of India.
Because the purpose I that the approval for by the appeal and
Yes.
deposit liberation of the mantra that has exercised as well.
This is for filing the demand draft, the amount.
The entire amount.
The entire amount.
Entire. Because the certain sanctions are required to be obtained.
So which took 90 days.
That's
What is the merits?
But still this appeal requires an interpretation of an office circular as well as terms of NJC entered in between the Steel Authority of India and the Union. Now that NJC contains a definition for theory of notional extension of time. That NJC contains a provision that when a person starts travel from the accommodation, Awas word is used, to the workplace, 1 hour for that is considered to be the time during the course of the time. Now, what happened in this case? We have allotted him an official quarter in sector 12. He was supposed to appear in our unit at 8 a.m. He died in a road accident in Chas. So we have, by exhibiting our NJC, tried to make out a case that yes, WC's Employees Compensation Act gives a room for theory of notional extension, but that notional extension is already agreed between the employer and employee that 1 hour from your residence to workplace. Now, while he has died at Chas, that is not the route from sector 12 to our workplace, and therefore, though he has died at 7:15, he is not covered within that theory of notional extension. Their case is that okay, you have allotted me quarter number such and such at sector 12, but it was not in good condition. So I was residing in some other private accommodation, and from there I was undergoing the journey. And since I died at 7:15 and I was supposed to join at 8:80 a.m., therefore it is within the period of theory.
Just one correction. Everything is said is correct. The one thing that the subsequent which was allotted to me, subsequent quarter which was allotted to me, it was allotted by BCCL only. It was a government quarter because the previous quarter was
BCCL was
BCCL.
Steel Authority.
You are limited.
BCCL quarter that we have.
Therefore, that is our case. You are residing in a private accommodation which is a PCCL quarter.
It is not
allotted
to me. BCCL quarter has been allotted because the previous quarter was in a damaged condition. It was
No,
defaced.
you are an employee of which undertaking? Steel Authority or BCCL?
Bokaro Steel Plant.
If you are an employee of Bokaro Steel Plant, how can you be allotted a quarter of BCCL which has got no concern with Steel Authority and Bokaro? And which doesn't even have, I think, any quarter in and around Bokaro.
जो यहाँ पर आया है, I'll just read that point. It is very relevant. The judgment itself. It is there.
Yes.
The fact is that he is a land user and he has got some accommodation in BCCL quarter, but BCCL has got no nexus with the
Land user BCCL took the land from me, and in that I have been
So therefore
I am aware.
So that means the BCCL has given you that same recommendation. So you are coming from BCCL quarters to Bokaro.
भवानीपुर साइड
So
और वहाँ भी ये काम करते थे, सेल का ही वो भी आया हुआ है गवाही, उसको इन्होंने कोई कहीं से भी
कहाँ काम करते थे?
तो भवानीपुर साइड के पास भी ये लोग ये काम करते थे, वही आवेदिता तो गवाही में आया पेमेंट।
So how can you work there?
ये सेल के ही काम से वहाँ पर जाते थे। I'll just may I refer to the judgment? It is there.
Because in this case,
Page number 6.
the LCR will be required because there the NKC is exhibited by us.
So you have taken that ground.
Yes.
That ground has been taken, and on that is only the entire judgment is there. That is the only.
The subtraction question number 1, 2, 3, 4, all like that. That is
And
in 50.
how it has been explained, क्योंकि जो सर्कुलर है उसमें बोला है कि अपने आवाज से, बट वो आवाज कहाँ है? It is nowhere given that where is that आवाज? वो आवाज क्या रहेगा? There is no clarity on that.
Give the call for the local records.
The Awas is required to be defined, whether it can be private or allot. As per us, Awas means what has been allotted to you. अगर नहीं allot करते, then you are personal. Otherwise, that tourism will be counted.
Yeah, we'll see.
Okay.
We'll see. So let the LCR come. What are the evidence which the parties have led?
Okay.
Serial number 33, ML number
Today, and this
34,
may be
50.
controlled if the LCR is required.
I'll find a reply now.
Is the case after two weeks?
No.
2 weeks, as the counsel for the respondent wants to file a rejoinder to the application to IA number so and so.
Okay. Keep it.
Serial number 33, ML number 334 of 16, Mr. Vikas Sinha.
Thus, in this appeal, I have filed an interpretatory application 7049 of 2021 for finding an additional evidence in terms of Article 41 to 27 on the ground that this additional evidence is a certified copy of an order passed by the Government Compensation Commission relates to the
Date of this order.
But date of this order is prior to filing of this appeal. But still I am saying that there can be 3 grounds to allow. This certified copy can be allowed without having any problem.
Yes, you want to file any rejoinder to this IA?
No.
Okay, let us hear this IA first.
But before coming to idea, may I just place back of the case and its statement, because we are here for the, even if there is no problem, if things that this is necessary can allow this, and it is just a certified copy, without forming it can be marked exhibit. Only exhibit number is required to be there. Whereas may straight away come to the impugned award. Why is
No,
it?
the impugned award is dated.
But impugned award is dated. This award is passed on 13/5/2016, and this additional evidence is of 10th of October 2014.
10th of
October 2014. Now, the owner is also party to this proceeding. This was never brought before the court, right? And perhaps the certified copy is latter of
You were a party to this proceeding?
Yes, I was party to this proceeding.
Which this
WC. Yes, I cannot even.
WC 5 or 30?
Yes,
Then why should you be
I
allowed?
come to running page 11 of my package.
So why do you want to? Why did you not produce this before the court?
That's the difficulty is जीत टॉप दोनों विपक्षी की ओर से न्यायालय से नोटिस निर्गत किया गया। नोटिस पाने के बाद विपक्षी संख्या एक जिला काउंसिल सेशन सचिव की तरफ से किया अधिवक्ता उपस्थित होकर अपना लिखित बयान करने का इसमें so I was there. But may only consider one. This is a finding by a lady.
Maybe. This will be considered only if I accept this in evidence. But why should I accept this?
But that is already referred to some extent. Paragraph 11 was also DW1, Rahul Banjar.
Show me any judgment under Order 41 Rule 27.
27 itself says 3 grounds.
Yes, show me any judgment of the Honorable Supreme Court that in this type of cases it can be allowed. Where you had participated in a proceeding, you want to bring on record the judgments or some order sheets of a proceeding.
27 subclause 3.
Yes,
That
yes.
the appellate court requires that document for just and proper adjudication.
Why should I?
But it's the appellate court because whatever finding will be, it will be in contrary to this. And therefore, in view to avoid the conflicting judgment, one by the definitely by some other subordinate court and one by the higher court.
Show me to avoid conflicting judgment. It can
Yes,
be.
yes, that appellate court so or even if not to be knowledge can take.
Show me the judgments.
1 week time. Today I know. Because basically I am here to write of recovery. The driver was assessed to be an underage and the deceased driver was denied compensation by that government compensation. This
Whether any appeal was preferred against that?
we have to notice. And here perhaps they have got the I am asking for the recovery from my driver and owner, not against the claimants. Not against the claimants. Whatever order will be passed will not affect the right of the claimants. Because what is my case? My case is that the claimant, he also happens to be a driver, the deceased driver. He was sleeping in a truck. The another truck, which was being driven by a minor and was insured with me, has dashed him. Both the driver died. The driver of that dumper, they have filed this present case. And I am the insurance company of a truck, offending truck, which is being driven by a minor. And this aspect was not brought to the market. Only this much is, whatever amount is there, I have this right to recover it. And that too against the owner of that truck. And that will serve the interest of the The owner was also participating there. He has also suppressed his fact. And by that time it was...
Can you take resort to Order 41 Rule 27 to cover up your latches? This is the question which I put it. Show me any judgment.
With Abhinav Misri court say I will talk. But that court can allow if it is required.
No.
Because it's not these latches I can say.
Yes. You appear in a proceeding, you participate in a proceeding, you know that there is a judgment, you don't bring it to the notice of the court.
That will be considered not by the tribunal paragraph 12 mark.
That has been considered.
Considered.
But it was considered that since here in June, there is only one Xerox copy, I will clarify that. There is a Xerox copy in which the DL number is given and the date of birth is given. So tribunal said that there is one Xerox copy and it shows he is 18 years old. Whereas by this judgment I am saying that this same.
How this court comes to a conclusion that he is below 18?
Because that is the finding by the when the case was filed by that deceased tribal's legal aid. Before that, Employees Compensation Commission. After full-fledged inquiry, the tribunal comes to a conclusion.
What is the basis? What is the basis of?
Because Aadhaar and everything was produced by the legal aids of that tribunal before the Workmen Compensation Commission. Those documents were not in my possession. There were not supposed A and B. A is the claimant, he has got nothing. B who has died. Their legal aids down to the Employees Compensation Commission. Aadhaar was and
Show me the judgment.
I will show it. All right.
On the request of
accident or you are attending medical.
Plus anyway he is not going to affect. It's a case of owner, he is not affected.
on the request of Mr. Kubash, analyze this case after 1 week. After 1 week.
Okay, 2 weeks.
2 weeks. 2 weeks.
Clear number 34, MA number 540 of 16, Mr. Shankarlal Agarwal for the petitioner.
Only what then can be seen regarding the mandatory buying also, because this applicant had no insurance that the man set up by her has been distributed by the court below.
No. Who was this? He was the. This lady was the claimant.
She was the non-claimant, she was the owner of the vehicle.
Right.
There are two vehicles.
Okay. You have been directed to pay how much?
5 lakhs. 10 lakhs was total amount of 10 lakhs. One friend had been got insured, 5 lakhs by the insurance company, and since this applicant has no insurance, she was directed to pay half of the awarded amount, that is rupees 5 lakhs.
So what is the wrong in this award?
Then only that by that multiplies with multiple 9 lakhs.
Multiplier is 13.
30.
Age of the deceased is 49, so it will be 30. So what is the ground you have taken? Let's.
By ground was the difference taken by the applicant that she had sold the truck to someone, other person, he could not make the transfer in his name because he was not liable. That was the only difference before the name. Although I said that nothing in sheet of paper has been shown and before this court, the substances are claimed regarding the defense.
Heard Mr. S. L. Agarwal appearing on behalf of the applicant. Let's start. Next paragraph. This appeal is referred against the judgment dated so and so. Judgment and award dated so and so passed by so and so in case number so and so. Let's start. Next. The applicant here is the owner of a truck bearing registration number CG 10ZB 0975. This vehicle met with an accident involving another truck bearing registration number BHS 9245. First off. The same, the vehicle being registered as BHS 9245 was duly insured with Bharti AXA General Insurance Company Limited. Respondent number 7. The vehicle of this petitioner admittedly was not insured. The tribunal thereafter who was the deceased?
Deceased was Manish.
The deceased was riding his motorcycle when these two trucks, which were being driven in a rash and negligent manner, both dashed the motorcycle. As a result of which, Suresh Kumar Ram died. First off, the claimants are the wife, children, parents of say late Suresh Kumar Ram. The tribunal, after considering the evidence and the material on record, has held that the claimants are entitled for a sum of rupees 8,02,000 Any interest paid? 02,000, along with the interest of 6% per annum from the date of filing of the claim application. Mr. Agarwal?
This is my filing mistake also. You have not. My filing mistake was very mistake.
The tribunal has directed that 50% of the compensation amount has to be paid by the applicants. Next part. Being aggrieved by the aforesaid judgment, the applicants have preferred this appeal. Mr. S.L. Agarwal, who is appearing on behalf of the applicant, has taken 2 points, has raised 2 points in this appeal. It is his contention that the multiplier used is 13. First up, as per him, considering the age of the deceased, which is 49 years, the multiplier could not have been could not have been taken to be could not have been considered to be 30. First up, he further submits that. What is your other ground? submits that the vehicle in question was transferred to one transferred to one Laltu Sardar, who had acknowledged the same transfer, but the but in the records of the district transport office, the vehicle was still recorded. The registration of the vehicle was still with the applicant. Established that since Laltu Sardar, to whom the vehicle was sold, transferred and sold, and had acknowledged that he would be liable for and responsible for any future claims coming, the tribunal would have considered that said agreement and should have directed Laltu Sardar to pay the amount of compensation. So, these are the only two grounds raised in this appeal. So far as the first point is concerned, I find that from the records and the impugned judgment of the court, I find that it is an admitted case that the deceased was aged about 49 years. Next up. Pranay Shetty. Sarla Verma, 2009 SCC. That is reference?
2017.
Volume 16. Pranay Shetty. In which paragraph the multiplier has been discussed? It has been said that the Sarla Verma will be
Yes.
so far as multiplier is concerned, that has been approved. Yes. Again, the Honorable Supreme Court, in the case of Pranay Shetty, others, in paragraph 42, has affirmed, has accepted the multiplier to be considered in considering the age of the deceased. The judgment of the Honorable Supreme Court in the case of Sarla Verma and others so and so, that is 2009 volume 2 SCC, 2009 volume 6 SCC page 121, Sarla Verma versus DTC, has formulated a table multipliers to be attracted, which will attract in considering the age of the deceased. As per the judgment of Sarla Verma and Pranay Shetty, Subra, the multiplier of will be applied for the age group when the deceased is in the age group of 46 to 50. Full stop. In this case, admittedly, the deceased was 49. Thus, the 13 is the correct multiplier which should be applied. Full stop. The tribunal has also applied the multiplier of 13 while computing the amount of compensation in this case. Thus, I find no merit in this point which has been raised by the counsel appearing on behalf of the applicants. Next paragraph. So far as the transfer of the vehicle is concerned, a plea has been taken by the counsel appearing on behalf of the applicant that the vehicle was sold to Laltu Sardar, who had accepted the responsibilities and in fact has indemnified the appellant against any future losses. The tribunal has found that the vehicle was still registered in the name of this appellant. The Honorable Supreme Court in the case of so-and-so versus so-and-so has held that the registered owner of the vehicle will be liable to pay the compensation. First up. Further, the law doesn't recognize these type of transfers. Full stop. As per the Motor Vehicle Act, the owner of the vehicle will be the person who is registered as the owner with the district transport officers. Admittedly, it is this appellant who is shown as the registered owner of the vehicle in the records which are maintained by the DTO. Full stop. The name has not been transferred in the records of the DTO in favor of Laltu Sardar. Thus, I have no hesitation to hold that it is the appellant who is the registered owner of the vehicle, who has to pay the amount of compensation. Full stop. Next part. Considering what has been heard above, I find no merit in this appeal. Full stop. This appeal is thus dismissed. Full stop. IA, there is an IA also. Let's see. It was filed in the year 2018. Most probably it has been executed also. Do you know? IA number 4612 of 2018. This IA has been filed by the appellants to stay the execution case number 15 of 2018 within bracket arising out of compensation case number 237 of 2011, which is pending before the District Judge 3, Roman 3, Motor Vehicle Accidents Claim Tribunal at Jamshedpur. Considering the final order which has been passed in this MA, being MA number 540 of 2016, and as the entire MA miscellaneous appeal has been dismissed, this IA number so and so is is rendered infructuous. It's also dismissed.
Respondent is made brother.
Full stop. Next paragraph. Main, right in the main. The appellant, the statutory deposit which was deposited by the appellant is directed to be refunded to the appellants. You take it back. I don't know whether the award has been executed or not. If it is executed, then